Hello friends, welcome. Friends, many of you who are following the telecom sector must have seen the Supreme Court order of rejecting the curative petition of the operators of giving them relief on the AGR calculations, the adjusted gross revenue license fee calculation, which emanated out of the Supreme Court judgment, where dues were levied on the operators on account of them not able to fulfill the obligations of payment of license fee as per the DOT's migration package. So everybody is aware of this order, and this has become a big bone of contention and impacted Vodafone Idea. Now what I am planning to do in this video is to take you through one by one what happened since the migration package, what kind of implications it has created in the sector, and what are the actions which the various education agencies like DOT and TRAI has taken, which has resulted in this outcome. Whether there have been some distortions, and if there have been some distortions, what are those distortions? So what I did, friends, is in the morning itself I wrote this article. So I think you might have, many of you who are following me might have seen this article which I wrote in Substract, which said that the title of the article is Navigating the Turbulence of Lessons from India's Telecom AGR Crisis. So you can go through this article and I'll go step by step because this will become a much more structural conversation, and I am going to point you to the documents, because this is not going to be a conjecture, right? I just don't write things just like that. I'm going to point to you the documents and then let yourself decide what kind of problems that we have encountered to ourselves, and who has to be blamed and how this issue needs to be resolved. Because after Supreme Court having rejected the curative petition, what are the remedies in before us? And that you can only decide by knowing the facts as to what happened since 1999. So let's go step by step, one by one, on the facts. And this article is going to become a point of reference. I encourage everybody to download or go into my Substract homepage. It's absolutely free. Download this article and read point by point. You will understand. And this is extremely important for the telecom sector, by the way. Not only for this issue that has been resulted, it is basically throwing a light as to how our ecosystem of regulation as well as our justice system is so fractured. Not that they intend to do that, but because of the way it is set up. And you will yourself be able to realize once having gone through these points which I am going to mention before you. Now what happened is, everybody knows that the judgment actually came on 1st September 2020, where the fines were decided. And these fines were very huge. Everybody knows about that. And Supreme Court now recently has dismissed the curative petition from the telecom operators, right? That's, everybody knows about it, and it is going to impact Vodafone Idea, and the stocks of Vodafone Idea is already down, right? And you can read one of my analysis which I have done regarding what kind of debt Vodafone Idea carries and what will be the implications going forward once this judgment has been delivered. Now let's go point by point. The first thing what happened was the migration package, and the migration package actually happened in 1st August 1999. Now why I am pointing to you to this document, which is the migration package? Because in this migration package, the definition of revenue was left undecided. Because you need to understand what was the situation before 1999. It was a fixed license regime which was converted to a revenue share based on a settlement between the operators and the DOT, because of the sector was getting bankrupt because of high commitment of license fee. So the DOT said that, okay, we are going to go for revenue share. You don't have to pay fixed license fee. Whatever is your revenue, give us a share. But the definition of revenue share was, which was supposed to be this particular fact that there has to be a license fee which is going to be on the percentage of revenue, but what will be the revenue was left undecided. Now I'll point to the document, because unless you see the document you are not going to believe, right? So this is the document. If you see this document, this is the migration package, and this was issued on 22nd July 1999. And if you look at this document, I have underlined, I actually gone through each and every document, I have underlined the document. What it is saying that on the receipt of, so what it is saying is on the receipt of TRI recommendation, the government's final decision, final adjustment on the provision of dues will be affected depending upon the percentage of revenue share and the definition of the revenue for the purpose of this purpose may be decided finally decided. Look, the definition of revenue, what will be the definition of revenue will be finally decided, and how it is going to be decided? Through a consultation process run by TRI. Okay, so this is very clear. And one more thing which is very important here, this was supposed to be signed unconditionally. If you go through this letter, what it letter says that this document, this whole migration package has to be entered into by the operators unconditionally. They can't really raise any point of protest regarding leaving the definition of revenue later to be decided by TRI. So this is one point. Now let's go to the second point, is that TRI went into a consultation process. So what TRI did? TRI came out with their own recommendation, and those recommendation was made available to DOT. So DOT had, what DOT did? DOT said that there is a pending promise, definition of revenue will be decided through a fair consultation process run by TRI. Understood? Now TRI went through the consultation process. They decided on a certain revenue structure, that non-telecom portion of the revenue will be extracted out of the overall revenue structure, so that the license fee will be paid only on the portion of the revenue which is telecom in nature. So they sent their recommendation to DOT, and what the DOT did, DOT basically made the following point. If you look at the back reference, and on the back reference which TRI is giving its own views on the DOT's back reference, you will find this is the clause. This is basically the DOT's explanation as to why DOT did not agree to the TRI's comments. TRI's revenue share or the revenue definition of revenue structure, why DOT did not agree. So DOT is saying what? DOT's comment is what? DOT is saying that government proposes to follow a definition of adjusted gross revenue for the purpose of computing license fee, which is different from what recommended by TRI. But DOT did not assign any reason. So when DOT is giving a view that it is not agreeing to the proposal which TRI has made on the definition of revenue for the purpose of calculation of license fee, it was the responsible of DOT to give some rationale. And why I am saying so, let's go to this particular document and it is going to be very clear to you. This document which says that, look at this document. I think I need to basically pause the video and find the document. Let me just, so you see here DOT's comment, right, which says that the definition of revenue share. So this is basically the back reference on which TRI is providing its own response on DOT's comment. So what DOT has commented? DOT saying government proposes to follow a definition of adjusted gross revenue for the purpose of computing license fee, which is different from the recommendation by TRI, but did not give any reason as to why it is planning to do so. And then TRI basically responded to the DOT's back reference, saying that DOT proposes definition of adjusted gross revenue, which is different from the definition of TRI. In this regard, it is observed that definition of adjusted gross revenue given by DOT in case of GMPS services seeks to include shareable revenue in number of items which do not arise from license activity. All miscellaneous income, including interest, dividend, write-backs, and earlier provisions, etc. This stance seems to be going beyond the terms of the license, therefore does not appear to be maintainable. See, this is what TRI is saying. On the other hand, the definition proposed by TRI, which has been recommended consistently, including the case of GMP and CMP, is clear that it is clear and precise enough to include all revenues which are accrued to the operator from license activity and excludes all items unrelated thereof. Thus, it covers all received from the provision of the basic services, including supplementary services, value-added services, subsidies, sale on handset, etc., while excluding items like interest, dividend, etc., which though constituting revenue cannot be said to represent the revenues arising from license activity. This is what TRI is saying. But TRI actually committed one major mistake. And what was the mistake that TRAI committed? TRAI should have formally requested DOT to provide a rationale behind proposing a different definition, right? But however, it did not pursue that matter. And the TRAI Act clearly, page 9 of the TRAI Act, if you go here, which I have listed down here, provided that also that the authority may request the central government to furnish information and all documents necessary for the purpose of making recommendation under subclause 1 and 2 of clause A of this section, and the government shall supply the information within the period of 7 days on the receipt of the such request. And what is the government did not do? Government, that is the DOT consulted a consultant. And it did not even place that consultant report, which is basically, because on the basis of the consultant report, DOT decided to charge license fee on the total revenue. But it did not, put the consultation report before the TRA at the time of the consultation process which was going on. So, if the consultation report is not made public, nobody knows about it, what is that report on the basis of which DOT has made its decision, then what is the mechanism? Does it not look arbitrary that DOT is decided to go with an approach which is different from the TRAI? It's completely arbitrary. So that is the reason why I believe that TRAI should have asked for a clearer explanation, and that was a missed opportunity by TRAI. Now let's come to the TDSAT issue. So TDSAT, what it said was that TDSAT gave a judgment in the favor of the operators. It said in the 30th August 2007, so it rejected the Union India's plea that SC has empowered in the 19th January 2007 order to urge all its contention, including which was settled in the earlier judgment of 7th July 2006. Let me just go step by step, because there are so many dates and so many points of discussion here, and you will get lost. So after this, there were many things which happened. I excluded those things because those are not very, very important from the point of view understanding the issue. So the matter went to TDSAT. TDSAT decided on 7th July 2006 on the favor of the operator. And what happened? DOT went to Supreme Court. Supreme Court then gave an order and basically told that look at this order. So Supreme Court on 19th January 2006, after this 7th July order was issued by TDSAT, heard the parties. It says that heard the parties pursuant to the directive of TDSAT, the impinge order. A fresh recommendation has been made by TRAI. In the interim, TRAI was also basically got involved and made a fresh recommendation suo moto. In view of therefore, there is no reason to interfere. Appeal is dismissed. With appeal, DOT's appeal is dismissed, and the appellant DOT is, however, given liberty to urge contention issues raised in this petition before TDSAT. So it's saying that go and raise all the contention issues, including those which were settled before, in the TDSAT order of 7th of July. Now, what TDSAT did? Now, TDSAT, when he looked into, because the extract of TDSAT judgment basically tells what TDSAT basically said. Now, TDSAT is saying that we have considered the contention of both the parties, and we are of the view that the appeal against the order of this tribunal, which is, what was the order? 7th July 2006 order, has been dismissed by the Supreme Court, and the order has become now final and cannot be reopened. So TDSAT is saying that, look, Supreme Court is now saying in the 19th January 2007 order that please go to TDSAT and address all your issue, and TDSAT is saying that no, I will not going to open my decision which happened in 7th July 2006. I am not going to do that because the order has received finality. But it was never final because of the reason when Supreme Court gave this order saying that please go to TDSAT again and reopen the case in lieu of the TRAI's consultation process which is on, the recommendation which is on. So it is also saying, and what TDSAT is saying, it is a basic principle of our jurisprudence, because the reason the TDSAT gave not to reopen the case again, that it is the basic principle of our jurisprudence that the authority passing an order cannot sit in the appeal against his own order. So you can imagine the technical issues that got entangled into this whole issue. So it did not follow Supreme Court judgment because of this particular point which he mentioned in their order, right? And therefore, Therefore, what it says, therefore, we reject the contention of the learned agency that he should be allowed to re-agitate all the issues raised by appeal against the order dated 7th July 2006, which was settled by TDSAT, which I mentioned here, right here, 7th July 2006 by TDSAT. Understood now? So this proved very costly. Why it proved very costly? When TDSAT went into this whole process and gave its own judgment, when SC came and SC told the DOT, please go again, right, to TDSAT and re-agitate all the issue, and TDSAT did not do that, then what happened? A lot of things happened in between. I have kind of excluded that. Then the matter actually went to SC again after this whole issue got resolved in TDSAT. And on 11th November 2011, Supreme Court came out with a judgment, and in the judgment, it quashed the jurisprudence, means the jurisdictions of TDSAT completely. It said that TDSAT does not have a jurisdiction, and it also mentioned a very important point that, if you look at it, it will clear from the language of the order that while dismissing the appeal, the court had given the liberty to the appellant, namely the Union of India, to urge all the contention of the issue raised on the civil appeal 84/2007. Imagine that this is what Supreme Court is saying in the 11th November 2011 order, where it quashed the jurisdictions of TDSAT. Matter is going on in TDSAT for such a long period of time, and later in Supreme Court had an opportunity that on, what was the opportunity? 19th January 2007. Why did it not look at the jurisdiction issue at that particular point of time? So the matter went to TDSAT. TDSAT did something and it gave a judgment. Matter went to SC, and SC said that, oh, by the way, TDSAT doesn't have a jurisdiction, and TDSAT did not follow my order in full, because I actually had mentioned in 19th of January 2007 to look into all the issue, and it did not look, and that became the reference point for rejecting the TDSAT order, right? So now you see this is getting very, very funny, right? Actually not funny, very painful. Imagine this whole thing that is going on, the ping pong game that is going on. Then the judicial oversight, this is another thing, the SC's delay in addressing the TDSAT jurisdiction, which I told you, that it had the opportunity on 19th of January 2007 when the matter went to SC after TDSAT settled. Then it on November 2011, 11th November 2011, it gave this order saying that tribunal has no jurisdiction to decide upon the validity of the terms of condition of the license. Why? Because it said that the jurisdiction of tribunal only comes when a licensee and the licensor has entered into an agreement. So when, let's say, if I am seeking a license and DOT is a licensor, now the terms of this license agreement between the DOT and the licensee has to be decided by the licensor and the licensee jointly. It does not happen like that. It's DOT which decides the terms and conditions, but TDSAT will not play any role, right, in deciding the terms of the license conditions. So what Supreme Court is saying, that the AGR definition lies within the realm of DOT, not within the realm of TDSAT, and therefore TDSAT does not have any jurisdiction, and TDSAT jurisdiction comes into picture only when there is a dispute on interpretation of the terms of the license. So the definition of revenue on a case by cases needs to be interpreted. It can't be interpreted in an overarching manner that what DOT has done by aggregating the telecom and the non-telecom revenues as a bucket together for the purpose of calculation of license fee can be challenged in TDSAT, because TDSAT doesn't have the jurisdiction. Now you got it? Now let's go to the next point. Then there is a critical omission of SC selective deliberation of AGR dispute. Now why I am saying this? The reason I am saying this is that when on 11th November 2011, when Supreme Court started deliberating on this issue, it had many points of question which has to be deliberated and scrutinized against law. So what were the point of questions, substantial questions of law? The question of law was whether the DOT had the right to re-agitate the same issue decided by TDSAT on 7th July 2006, which I already mentioned. They decided and Supreme Court said that please go and decide the case again, or go and re-agitate your case against TDSAT, which TDSAT never did. Second is whether TDSAT has the jurisdiction to decide the terms and conditions of the license, which I said that why Supreme Court decided against it, that TDSAT doesn't have the jurisdiction. Third was whether DOT not filing an appeal against the order dated so and so, which is the 7th July of TDSAT, passed in favor of the licensee, the said order has become final. That is again another point. And whether the licensee can challenge the computation of AGR, and if so, at what grounds. But there was one important point of law in question which was not challenged. What was that? That whether DOT can reject Trais recommendation without assigning any reason arbitrarily, whether it is fair on behalf of DOT to structure the contract with such ambiguity that the terms of which the DOT can finally unilaterally change at later any stage without assigning any reason. This is a point of question which the Supreme Court should have taken into consideration, because I'll tell you the reason why this is so important. If DOT has such power to unilaterally decide anything at any point, then what is the point of having a consultation process with TRAI? That process can be very easily excluded. There is no point in having a consultation if DOT can decide everything whatever it wants without assigning any reason. And this is the problem in our system, and that needs to be rectified. If it is not rectified, then whole process of doing all kinds of consultation process and the views which are being expressed by the licensee and other stakeholder is immaterial. It is a complete waste of time. And this was a very important question of law which the Supreme Court should have adjudicated, and if it did, it would have created a big precedence and a great help to the process of consultation and the education on the basis of which lawmaking is done in our country. Because lawmaking sometimes becomes completely arbitrary. Even there is a consultation process, it is basically done from the purpose of just filling ticking it's just a placeholder or tick marking a particular action item from the point of view of consultation. Even sometimes I have seen TRAI, after listening to all the stakeholders, passes its own judgment without assigning any reason. So this party said this, that party said this, there is an opposite view and we believe this. But there is no reason for that. Why you believe this? You have to substantiate with clear point of reason as to why you believe this. You can't simply say that this party said this, that party said that, and we believe so. It does not make any sense. It has to be substantiated with facts and figures and rational, right? So this is very, very important. Now comes the judicial inconsistency, SC's arbitration of blame of AGR on the operators. Now, if you have seen that in the order of October 2019, the Supreme Court put all the blame on the operators for the delay. Now, after having discussed all this issue till now, do you think that it is the blame should lie on the operator? The ping pong ball between all the education agencies, TDSAT and Supreme Court, TRAI, was going on, and DOT was kept on agitating the same issues, right? So there was no point in putting the blame on the operators because they caused the delay, and maybe they did because they could have done something else, which I'm going to come later in my video. But you can clearly see that there was no point. If you go through the process of TDSAT, and the TDSAT spent so much amount of time educating the matter and coming out with this recommendation, and you went to Supreme Court and Supreme Court says that TDSAT doesn't have jurisdiction, then what is the point in wasting so much of time? You could have done in 2007 itself when the matter came to Supreme Court. It should have been done, nah? It should. Otherwise, why waste so much amount of time, right, doing this education, right? And then it never decided, arbitrariness of DOT deciding this matter of revenue share, right? Then selective exemption of SC's arbitrary ruling and the TDSAT clarification later. Why I am saying so? Because that the issue of license fee getting applied on a club revenue of telecom and non-telecom applied to the PSUs also. Now, what Supreme Court did is it actually went through the license condition for various operators. or the various licensees. So it found that the license condition for NLD and IP2 licenses are different from that of the USL and the ISP license. So Supreme Court found that. It says that, and there was a clause, and it is getting into a little bit of technicalities, and I don't want people to get confused. So let's understand this, that NLD and IP2 license are different. You can read through my note and you'll get better clarity. But USL and ISP license were similar. And the PSUs held the USL ISP license also, right? And they were selling commercial services to the consumers like RailTel. So how the USL and ISP licenses of the PSU should have been segregated into two different compartments and two different treatments should have been provided when it was clearly established that the telecom revenues would be paid on the total revenue, not segregating revenue. There was no clause which says that if you are doing ISP or if you are doing mobile services, you would be treated differently. License did not say that. So Supreme Court made an interpretation which was completely out of the way. That look, the PSUs are different, the mobile services were different, and no, solid rationale was given except for the NLD and the IP2, and that created a problem that the operators who are providing mobile services were selling commercial services, and those PSUs like RailTel who are selling ISP services, they were treated differently. And that is very, very wrong from a legal point of view, because if the license condition says, how can you basically have different people getting treated differently? So what happened was, Telecom Dispute Settlement Tribunal, TDSAT, noted this in February 20th, 2022 in the NetMagic case. It said that, look, if you are going to treat the ISP operators differently from the USL operators, then you can't really make a distinction between the private sector ISP operators and the public sector ISP operator. NetMagic was a private sector ISP operators, and the government basically levied a revenue on NetMagic, license fee on NetMagic, which was the total revenue, right? So NetMagic said that, look, I am not going to pay because the PSU operators are not paying. And that's what the Telecom Dispute Tribunal basically mentioned in their judgment. And if you read the judgment, you will figure out that how sad the situation is, right? So now comes to the main point of the discussion on which the curative petition was filed. The curative petition was filed. Forget about what happened in past. Operators never wanted to reopen the case. They were only interested in the preliminary assessment point, which was mentioned in the SC judgment of 1st September 2020. The preliminary, because if you look at the SC judgment of 2000, let me just see if I can find this, because otherwise it will take a lot of time. I don't want to waste time of the viewers. Let's forget that. Everybody knows about it. If you go to this, and you will find that the preliminary assessment word has been used. It is not a final assessment. So what the clause 38 of the page 46 of the judgment is produced for reference, which I'm going to read out, that the demand raised by Department of Telecommunication in respect of AGR dues based on the judgment of this court there shall not be any dispute raised by any of the telecom operators, and there shall not be any reassessment. And this is the point which the judges now at the Supreme Court has caught. I believe so. Because it is clearly mentioned that there cannot be any reassessment. So how can now they decide on the reassessment? Unless they go into the root cause of the case. You have to read all the papers. Who has the time to read everything? So they will go with what the Supreme Court judge actually at that time point have said. And therefore the curative petition got dismissed. You understand? So now it is clearly understood that there was some problems. And those problems should have been resolved by the parties amicably. Means the operators were also responsible. They overlook an opportunity for early settlement and reform. Why? Because they were getting benefited by the AGR system. Now many who have not followed the system from the beginning will not know that. See, the revenue share system actually had favored the GSM operators. Why? Because the battle was going on between the GSM and the CDMA operators from the point of view of competitive advantage. CDMA was an efficient technology. Now, if you dismantle the revenue share regime by stating that now you're going to come out with an option process which started in 2010, there could have been plea made by the operators that we don't want any no longer revenue share regime because it has outlived its utility. Now you're going to auction the spectrum. So let's dismantle the revenue share. That could have been made. Nobody said that because CDMA was given half the quantum of spectrum compared to the GSM operator using the revenue share regime. And if they had dismantled the revenue share regime, they would have lost the competitive advantage. And the matter went to such a level of bizarreness. If you see, Ratan Tata made a proposal of 1500 crore for 3G spectrum, and that led to a criticism from the various industry leaders saying that if the Ratan Tata has got a lot of money, he should pay to the Prime Minister Relief Fund. You can imagine what is going on in the system. So you want to perpetuate a system for your own advantage, and you know that the system is wrong, and you are fighting that system in the court of law. So you can't have the cake and eat it too. So in my view, the revenue share model should have been dismantled immediately as soon as the government delinked the spectrum from the license, which they did in 2012. Actually, they did in 2012, but that should have been done earlier. And when 2010 auction started, spectrum auction started, there should not have been any revenue share because spectrum was given based on license fee on auctions anyway. So I think now you probably know the conclusion of this protracted litigation. And this is a very, very long story which I have tried to cut short because I have gone through each and every document. See, this is not, I am not doing this just like that. If you look at I have underlined all this document and gone to each and every judgment and gone through the pain and reading the judgment. Like this is the order which I was talking about where Supreme Court basically talked about why PSUs are to be excluded from this judgment. And then, so this is the point of contention, and the video actually has gone to more than 30 minutes, which I really didn't want the video to go to 30 minutes. But this is a very long issue. Everybody has to understand that this issue actually has created more losses than any benefit. DOT now has to collect the payments from the operators who do not exist. Some of the operators have vanished from the scene. Vodafone Idea, if you do the calculation for Vodafone Idea's interest payment, it is going to basically become as equal to their revenues, right? Interest payment and the payment of principal, it will become equal to the revenue. There is no way the Vodafone Idea will be able to pay this. And if Vodafone Idea does not pay, from where the DOT is going to collect money? So what is the point in having re-agitated this issue for such a long period of time? Who gains? Who gained from this system? You have completely destroyed the sector. The competitivity of the sector has been destroyed completely. The money cannot be collected, right? So ultimately, it is a lose-lose situation for everybody. Nobody has gained from this. And the consumers have lost miserably because now there will be only two operators. And resolving this issue with more than 2.2 lakh crores of debt, which Vodafone Idea actually carries from the government side, resolving that will be extremely difficult for DOT because I have done an article. I am going to paste that link in the description. The Vodafone will become a government entity if you are going to convert the debt to equity, and the value of the equity will plummet down. So DOT is not going to collect any money. So that's the whole point here. Anyway, friends, I'm not going to go further than this. I probably think that I have spent maximum time that is possible to explain to you what the situation is, because I felt necessary to do that, because this is a painful process going through. Because if you do not know the history, you will not be able to realize that who committed what fault and where the situation is. Otherwise, no corrective action can be taken. Thank you for your time, friends. I hope that you have liked this video, and let me know anything that you need to know in the comment section. I'll get back to you if I can. I'll come back to you with a new video next time.